Hello and welcome to today's immigration video on the Ray Law International channel. In my 22 years in immigration law, I've worked with a great number of clients. Many of the clients who come to us have attempted to submit applications only to be faced with a denial. Today, we'll talk about one such procedure designed to give applicants a second chance: the USCIS motion process. When you receive an unfavorable USCIS decision, your decision will tell you whether you are eligible for review. There are two methods through which you may submit a request for review. This may be done through an appeal or a motion. If your letter states that you are eligible for review, you may always submit a motion. That is true even in cases when an appeal is not allowed. Here is how the motion process works.
Where do I submit my motion?
Your denial notice will provide information on where to file your motion. It will ultimately be reviewed by the Administrative Appeals Office. There are often changes in filing locations, so take care to double check and confirm the filing location. If the filing location is not specifically provided in the decision, visit the USCIS website and check the filing location for Form I-129B.
Who may file a motion?
Often, it is the petitioner. There are limited circumstances in which the beneficiary may be entitled to submit the motion.
Are there different types of motions?
Yes, there are two types of motions: a motion to reopen and a motion to reconsider.
A motion to reopen.
First, there's a motion to reopen. A motion to reopen is a request to have the decision reviewed based on new facts. The motion must be paired with documentary evidence to prove this. They must be facts that were not previously submitted to the USCIS.
A motion to reconsider.
Next is a motion to reconsider. A motion to reconsider is a request to reconsider the application based on an incorrect application of law or policy. It must be supported by citations of laws or regulations.
What form is used to file the motion?
Most appeals must be filed using Form I-129B, Notice of Appeal or Motion. There are a few exceptions where you must use a different form. Your denial letter will contain information regarding which form to use and where to send it.
Do I have to submit any documents with the motion?
You don't have to. If you do choose to submit a brief, you must address any issues of legal or factual error. You can submit your brief and supporting documents with the filing of the motion or, when allowed, within 30 days after you file your motion.
When is the deadline for submitting a motion?
In most cases, the deadline for submitting a motion is 30 days from the date of the decision. This means that you must submit a motion within 30 days from the date that is written on the letter, not the date that you received the letter. You must also indicate whether it is a motion to reopen or reconsider.
When can I expect to hear a response?
The USCIS will attempt to complete your review within 90 days or, in some cases, within 180 days from the day they've received a complete file on your case. In many cases, it will take longer. As we mentioned, sometimes your motion will benefit when supported with a brief, which discusses the facts and the law. That's why it is so important to consult with an attorney to give yourself or loved one the best chance of success. Now, more than ever, it is important that you have an immigration attorney involved in your immigration case. Get the Ray Law Advantage. Get the information and knowledge you need to have peace of mind. Stay updated on immigration matters by subscribing to our channel and sharing these videos with your friends. Stay informed, stay educated, and until next time, stay on the right immigration path.